My name is Jelena Bajin and I'm a lawyer in the law office of Tomislav Šunjka from Novi Sad. When dealing with our clients' debtors, their unfulfilled obligations, other claims, and enforcement and litigation procedure in general, the law office of Tomislav Šunjka conducts a certain due diligence of the debtor where we assess his assets, his claims, his other dues, his shares in other companies, in order to gather the information to decide on future actions. The goal of this due diligence procedure of the debtor is determining which asset of the debtor will be most suitable for the enforcement even before the court procedure has even been initiated. An interim measure as a mean of security can be determined by the court and implemented by the court or the private executor before, during and after the completion of particular judicial or administrative proceedings until the final completion of the enforcement. The law on enforcement and securities prescribes various types of interim measures, for example, forbidding the debtor of disposing of his movable property or his real estate, or confiscation of his cash and other valuables. However, the law prescribes the possibility of determining an interim measure other than the ones that are prescribed by the law if it achieves the purpose of determining such a measure and on the proposal of the creditor. Interim measures in general can be a forceful mean of securing a claim, especially when having in mind the previously mentioned possibility. In this way, the creditor and hence the court are not limited with only those interim measures that are prescribed by the law. Interim measures may be rendered to each individual case and having in mind particular circumstances. In order for the court to determine and establish an interim measure, the creditor has to make plausible the existence of the claim. There are two conditions that the creditor has to fulfill in order to successfully establish an interim measure in a particular case. Firstly, the objective condition, and that is the probability of existence of a claim. This can be managed with various means, for example, by submitting certain documentation that prove the existence of a claim, certain contracts, unpaid invoices, other accounting documentation, or presenting other facts that make the existence of a claim plausible. Secondly, the subjective condition, and that is the existence of a risk that without establishing such a measure, the debtor will prevent or significantly hinder the collection of such a claim by disposing of his property or otherwise concealing it. It is considered that such risk exists in particular, for example, when the claim is to be implemented abroad. For example, if debtor's legal obligation established by a final court or administrative decision are higher than his regular income. If debtor already previously refused to give informations of where his assets are or already gave false informations. In nature of things, the subjective condition is usually more difficult to be proven, however not impossible, as our practice has shown. When interim measures are in question, the circumstances of every particular case has to be meticulously asserted and examined. In this way, we determine the existence of the claim and the existence of a risk for such a claim, and which interim measure or which special interim measure will be most suitable for that particular case. Only when examining every particular case in this way, the interim measure has its point and achieves its goals, and that is establishing interim measure, securing the claim, and finally successfully collecting it.